Thank you for joining me today. My name is Michael Wollstonecroft. I'm a partner at RWK Goodman, and today I'll be discussing low exposure mesothelioma claims in the context of the recent Court of Appeal decision in Johnstone and Fawcett's garage. The presentation will cover the key legal principles, significant case law, and the implications of the Johnstone case. The first slide is a brief overview of what we'll be looking at today. We're going to look at the key legal principles and cases that have shaped the landscape in recent times in mesothelioma claims, especially in the context of low dose. We'll discuss the Fairchild exception and go back to basics. We'll look at Sinkovich and the absolute risk approach that the Court of Appeal labelled that approach in Johnstone in the appeal, and also we'll look at Bannister and Freeman's. We'll then move on to case law leading up to Johnstone at first instance, and then we'll look at Johnstone, we'll look at the facts of the case, the implications, and then we'll have a brief discussion about the practical effects of the Court of Appeal's decision. So first of all, I think it'd be helpful for us to go back to basics and look at Fairchild and Sinkovich. The Fairchild exception, as it became to be known, addresses the difficulties with the usual but-for test in the context of mesothelioma litigation. In the context of mesothelioma, the usual but-for test for causation is problematic because mesothelioma is, firstly, an indivisible disease, and per Ministry of Defence in AB, where the judge stated one either gets cancer or one does not. The condition is not worse because one has been exposed to a smaller amount of the causative agent. So frankly, it's impossible on the basis of medical science currently to identify which asbestos fibres trigger the disease. However, using the Fairchild exception, it is enough to show that a negligent exposure has materially increased the risk of the development of mesothelioma.